Just went off and hit her in the chest. It was the most terrible thing I'd ever seen.
Just shocked, frankly. Immensely tragic. The two kids and the family.
Of the three women who were 18 years old at the time, some of them, they were more than one time.
In June 2001, Texas-born Andrea Yates was charged with the deaths of her own 5 children.
Cops were crying. There was a lot of emotion.
At 37, Andrea Yates was convicted of 2 counts of murder and sentenced to life in prison. However, her verdict was reversed on appeal, and in 2006, Yates was released on bond. She suffered from severe postpartum depression, postpartum psychosis, and schizophrenia. Her husband, Rusty, initially supported her, telling the media in 2001 she loved those kids. The following day, she was admitted to a psychiatric facility, where she remains today. Her high-profile 2002 trial gained national attention and was even broadcast live.
Really easy to get caught up in, like, oh, you know, how they suffered or the fact that they're gone, you know, and what I tried to do was say, look, I'm not going to let these events.
On January 23, 2010, Neil Jacobson shot and killed his wife, Frankie, and their twin boys, Joshua and Eric. This shocking crime devastated their community in Wellington. Jacobson, known as a loving husband and father, committed the murders just weeks after being prescribed the antidepressant Zoloft and the anti-anxiety medication Xanax. Now serving 3 life sentences, Jacobson has never denied his actions. The family had been struggling financially after moving, compounded by the country's financial crisis. Jacobson was diagnosed with vertigo and depression following complaints of dizziness and lethargy after Christmas. Family and friends noted that his personality changed rapidly after he began taking the medications. He started hallucinating, became anxious and paranoid, and struggled to sleep properly.
He took the best that God had really given him and destroyed it.
You can't get rid of this overwhelming pain, overwhelming grief by yourself. I got rid of the grief and was able to move on.
We did reach out for him, and together we can speak, and he had a family on both sides.
About 3 weeks later, Neil Jacobson committed the horrific act just hours before his son's birthday party was set to begin. Prosecutor Andrew Slater argued for the death penalty. To avoid this possibility, Jacobson's public defender hired an expert to testify that he had been insane at the time of the incident. However, Jacobson's lawyers doubted the jury would be convinced of his insanity. They urged him to plead guilty to avoid a death sentence, leading to his current 3 life sentences.
Mr. Jacobson, you are here for 3 counts of first degree. The bond is presently scheduled at 9.
Jacobson accepted the plea deal, but later attempted to take his own life in prison, stating that he didn't think he deserved to live. He said he had an amazing relationship with his wife, describing them as best friends. He also said, "There's not a day that goes by that I don't cry." A Houston man who allegedly shot and killed his girlfriend in 2006 is now in the custody of Mexican law enforcement officials after being a fugitive for more than a decade. William Joseph Greer, 52, was arrested following a joint operation by the U.S. Marshal Service, the Harris County Sheriff's Office, and Mexican authorities in a remote city in the southern Mexican state of Tabasco. He's been a chameleon for 11 years, said Chief Deputy U.S. Marshal Richard Hunter. Greer is accused of shooting and killing his 28-year-old girlfriend, Tammy Marie Esquivel, at their home in Spring on December 19, 2006. 3 days later, before law enforcement officials discovered the crime, Cleveland police found Greer wandering half-naked and drunk in a field, with his car in a ditch. Dashcam video from the arresting officer's vehicle recorded Greer admitting to accidentally shooting Esquivel in the chest during a domestic argument.
Some kind of substance. I don't know whether it was alcohol or narcotics or what it was. A short sleeve button-up shirt is the only thing he has on. Just went off and hit her in the chest. It was the most terrible thing I'd ever seen.
He was arrested for public intoxication, but without any evidence to verify the confession, officials released him the next morning. The confession became evidence when Greer's sons told police on December 30th that Greer had dragged Esquivel into the master bedroom of their home in North Houston. The boys recounted hearing their father and Esquivel arguing through the bedroom door, followed by the sound of a gunshot.
I wonder how scared they must have been when they heard They finally told their mom something bad has happened to Tammy. We're so scared to go back to that house where they knew that Tammy had been.
They also heard Greer asking Esquivel if she was alive, followed by silence. A federal grand jury indicted Matthew Taylor Coleman of Santa Barbara for taking his 2 children to Rosarito, Mexico, and killing them. On the afternoon of August 7, 2021, Coleman was packing for a family trip with his wife, Abby. Suddenly, he took his 2 children, Callio and Roxy, and drove away from their Santa Barbara, California home. Crossing the border into Mexico, Coleman ended up at the City Express Hotel in Rosarito. He stayed at the hotel for 2 days before allegedly taking Callio and Roxy to a nearby ranch where he killed them. Coleman reportedly told police he was motivated by a conspiracy theory, which falsely claims that former U.S. President Donald Trump has been secretly fighting against a faction of Satan-worshipping pedophiles in positions of political power and influence.
Just shocked, frankly. Immensely tragic. The 2 kids and the family. It's just awful.
In a subsequent 30-page search warrant application, Coleman's alleged conspiratorial thinking was detailed further. The affidavit claimed that Coleman was fascinated by conspiracy theories and interested in Strong's numbers, an index of every word in the Bible. Coleman allegedly told agents that while in Mexico, he had lain in bed and experienced visions, saying he saw all the pieces being decoded. He said that these visions and signs revealed that his wife possessed serpent DNA, which she had passed on to their children, and that all indications pointed to the idea that his children had corrupted DNA that would spread if he did not take action. Coleman has been charged with 2 federal counts of killing U.S. nationals on foreign soil. Daniel Hears, a former South Carolina police officer, was caught after 13 years on the run. He was arrested in China. A U.S. Marshal spokesperson announced that U.S. Marshals captured Dan William Hears in Shanghai, China. Hears had been on the run after allegedly killing his wife and molesting a girl.
But I felt very safe because, as a police officer, you're here to, protect. Try to touch me in inappropriate places. They wouldn't believe me if I told. He was like, I'm a police officer, they're not going to believe a little.
Daniel Hears had assumed the name David Williams. His arrest came after an allegation emerged on Chinese social media, where a woman surnamed Wang claimed that while browsing the U.S. Marshals Most Wanted list, she recognized Hears as a former English teacher at a Chinese university. The former student claimed that Hears harassed her friend after she turned down his advances. The U.S. Marshal's office stated that Hears betrayed his badge in the worst way by using it to get close to the girl and her single mother over a period of months.
He was brought up in the church, good Christian family. I did trust him. Now I know what was going on. Now I know.
On the day Hears was supposed to turn himself in, he fled. Police later found his wife lifeless in a bedroom with a gunshot wound. He was one of the top 15 most wanted fugitives. A spokesperson for the U.S. Marshals said, "Those are always big." The Holy Fire was a wildfire that burned in the Cleveland National Forest in California, starting on August 6, 2018, near Trabuco Canyon. The suspected arsonist, 51-year-old Forrest Gordon Clark, was booked into the Orange County Jail in Santa Ana, California. The blaze burned 23,136 acres and destroyed 18 buildings before it was fully contained. The fire was ignited near a cabin owned by Clark in the Holy Jim Canyon community.
Wavering and advisement, directly of not guilty.
Yes.
All right, thank you, sir. Is your date of birth December 29, 1966?
Yes.
He was arrested on August 8, 2018, and booked into the Orange County Jail on suspicion of 2 counts of felony arson, 1 count of felony threat to terrorize, and 1 count of misdemeanor resisting arrest.
As far as a possible additional suspect, there's no credible evidence to suggest that is the case, and we're confident that Forrest Clark is the correct suspect. That's right. It was something that, as discussed in court, it was brought up as a thought or an alternative theory on the case.
A double murder suspect on the FBI's 10 most wanted fugitives list was captured in Mexico after 16 years on the run. Octaviano Juarez Coro, who had been added to the FBI list, was apprehended by law enforcement in Guadalajara after authorities received a tip about his whereabouts. Juarez Coro was wanted for a brazen shooting at a busy Milwaukee park on Memorial Day in 2006. During a picnic at the lakefront park, he allegedly pulled out a gun and fatally shot 2 victims, wounding 3 others, including his estranged wife, according to the FBI. Octaviano Juarez Coro spent the last 16 years running from law enforcement, hiding in another country, and believing time and distance were on his side, said Michael Hensel, special agent in charge of the FBI's Milwaukee field office, in a statement. Marlon Coy, 56 years old, was convicted of setting the devastating Bear Creek Fire and was sentenced to 27 years in state prison. The Bear Creek Fire 2017 destroyed homes, injured over a dozen firefighters, and burned 400 acres. Coy started the fire during a dispute with a man he believed was stealing from him. Earlier that day, Coy had enlisted 3 friends to help him retrieve his property. By late afternoon, his friends grew suspicious of Coy's erratic behavior and began to leave the property. On their way out, one of them noticed Coy starting a small fire near a campsite and poking it with a stick. He then saw Coy start several other small fires by pouring gasoline from a red gas can and lighting them. The fire quickly spread out of control. Coy is housed at San Quentin State Prison and is not eligible for parole until 2039, when he will be 76 years old, effectively making his sentence a life term.
Let's be honest, he lit a fire that caused an evacuation and burned 300 plus acres. That's not something that happens every day in this county. It's arson, it's not an and the message should be that we are going to come after you if you do those sort of things in this county.
Marlon Coy was convicted of 15 felonies, including arson, causing great bodily harm to emergency personnel, and being a felon in possession of a firearm. Michael Eugene Moore, a Virginia fugitive, was caught on the run after 26 years. Authorities say Moore, who was featured on America's Most Wanted 2 decades ago, was arrested after a 3-hour standoff with deputies in Florida. The Flagler County Sheriff's Office reports that the 46-year-old Moore had a fugitive warrant in Virginia. He was featured on the TV show for allegedly knifing his wife repeatedly and abducting their daughter in March of 1996.
He located the kids here and there because he knew where we were at all times somehow. Having to convince cops they need to do more, they need to hurry, they need to catch them. Being scared, always looking over my shoulder. I wanted to do by cop, so they wanted me to not talk to him, not give in to him, because if I was talking to him, if I was giving him that attention, he most likely would have done that, and they wanted to prevent that.
Weeks later, the girl was found in Miami and returned to her mother in Richmond, Virginia, after the child's photo appeared on the show. However, Moore remained a fugitive until his recent capture.
I heard her crying, "Daddy, don't hurt Mommy, stop hurting Mommy."
The sheriff's office reports that a license plate reader detected a stolen vehicle, and deputies signaled the driver to stop in Palm Coast, south of Jacksonville. Moore initially refused to exit the vehicle but surrendered after the sheriff called in a SWAT team. Michael Eugene Moore will serve more than 20 years behind bars. He was accused of tying up a woman outside an assisted living facility and stealing her car on January 19th. Moore was charged with carjacking and sentenced to 50 years in prison, with 35 years suspended. He was also charged and convicted of abduction, receiving a 10-year sentence. Additionally, Moore was charged with the use of a firearm in the commission of a felony, which carries a 3-year sentence for the first offense and, by law, requires 5 years for the second offense. Prosecutors stated that the abduction charge runs concurrently with the carjacking charge, leading to a total of 23 years in prison. "I'm happy to hear that he's off the streets for good now," said Amanda Moore, Michael Moore's estranged wife. From 1985 to 2000, Thomas Sweat terrorized the Washington, D.C. metro area as a serial arsonist, whose crimes claimed the lives of 3 people and caused injuries to many more. Sweat told a reporter that the fires were partly about power. He said he sometimes set fires because he didn't want his victim to drive a specific car or felt the desire to own the victim's house, turning the fire into a weapon to destroy it. He admitted to pleasuring himself as he left the scene. When authorities apprehended Sweat in 2005, he confessed to a fire in 1985 that destroyed the home of Bessie Mae Duncan and Roy Pickett. Investigators had initially ruled the fire an accident caused by a carelessly discarded cigarette. The couple's children survived, but they didn't learn until decades later that Sweat had purposefully started the fire. Authorities arrested Sweat in 2005 after a 2-year manhunt. They charged him with over 40 fires, but he has since confessed to 309 additional fires, making him one of America's most prolific arsonists. Deemed a sociopath by some, Sweat seemed eager to brag about his crimes, which is why the public knows the true extent of his actions. Allegedly, the fires provided Sweat with a sense of physical gratification and power. A jury sentenced Sweat to life in prison plus 136 years. A man who spent time in Shawshank State Prison and later escaped from an Ohio prison farm is back in police custody after 56 years on the run. Frank Freshwaters, formerly of Akron, Ohio, was captured in a remote part of Brevard County, Florida, by members of the U.S. Marshals Service. Freshwaters, 79, was convicted of vehicular manslaughter in Ohio in 1957 and received a suspended sentence of 1 to 20 years in prison. He was imprisoned 2 years later for obtaining a driver's license, a violation of his probation. According to the Brevard County Sheriff's Office, Freshwaters was first sent to the Ohio State Reformatory, the same prison used in filming The Shawshank Redemption. He was later transferred to the lower security Sandusky Honor Farm, where he escaped after serving just 7 months of his 20-year sentence. After escaping, Freshwaters assumed the alias William H. Cox. They worked as a truck driver in several states before retiring in Florida, where authorities eventually caught up with him. A cold case unit in Ohio traced Freshwaters' trail over the decades to Brevard County, where they requested local deputies' assistance. Authorities confronted Freshwaters outside his trailer and showed him his 1959 mugshot. According to U.S. Marshal Pete Elliott, he admitted his identity and owned up to everything. Freshwaters is currently being held at Brevard County Jail on a fugitive from justice warrant and will later be extradited to Ohio to face charges for escaping prison. This arrest was not the first time Freshwaters faced authorities since his escape. In 1975, he was arrested in Charleston, West Virginia, based on his Ohio warrant, but a judge refused to extradite him, allowing Freshwaters to disappear again. After 56 years of freedom, the marshals believe it is time for justice to take its course. Mr. Moore claims that his wife is unsure who the father of her daughter is.
How has the doubt about little Zania's paternity affected your connection to her?
There's no contact. I made sure that it wasn't going to be any contact till I found out for certain if that was my daughter.
All right. Were you ever in a committed relationship?
Absolutely. She told me that she was pregnant, but she waited 4 months to do it. Keep in mind, we stayed using condoms all the time.
You didn't tell him you were pregnant until 4 months.
I didn't tell him I was pregnant because it was something I went to the doctor in Alabama, and they didn't tell me. They didn't know if my baby was going to be alive or dead.
We can stop playing victim, though.
So I didn't show you the papers?
I got these papers. Her uploading pictures with the guy who was presumably, he could be the dad.
This is Ms. Matthews kissing another man.
Yeah.
And how did you find this photo?
That actually came from her social network that she used to have, her Instagram.
What picture did you post? And the reason I did bust the window out is because I was calling his phone about this picture. It was a brick by the tire, and I broke your back window.
Okay.
You're in a relationship, what you guys call a relationship. However, one Throwback Thursday, you post a picture of you kissing somebody else.
We weren't together at the time.
So you posted this picture, which then fueled your doubts that you might not be the child's father because she also had a picture. You're admitting today in open court that you busted the window out of
Stop lying.
his
What's
car.
wrong with you, man?
I don't have to lie about what I do.
The night she busted out my windows from me uploading a picture with another girl on my social network.
Is this the window you busted out?
I busted it out. I should have got the site too.
Why do you have doubt that your uncle is the father of Ms. Matthews' child?
Because Ms. Matthews, she gets around. The whole hood knows her. It's nothing new. She gets around. Let's not play crazy.
The back page? So hold on, Ms.
Don't take care of your daughter. That's what you need to do.
Ladies, do you have any proof, not just known around the neighborhood?
Yes. The day after prom, I seen her with some dude that looks exactly like my uncle. So I called my uncle up and I'm like, Mrs. Matthews is here with some dude that looks just like you. She calls 3 other dudes in the neighborhood that we live in daddy.
That just sounds ridiculous. No, my daughter did not call anybody else daddy.
Does she call Mr.
don't
Moore
even call
daddy?
him daddy, no.
Ms. Matthews, who signed the birth certificate?
My name is on the birth certificate. It's right here, Your Honor, if you'd like to see it.
Listed under mother's name is, of course, your name.
Yes.
And father's name is
Question
blank.
mark, nothing. Yes, blank.
Mr. Moore, you didn't sign the birth certificate because you weren't sure. Because you weren't sure.
Yeah, she do got love for her daughter. I'm not trying to say she's a bad parent. I'm here for one thing and one thing only. I need to find out if I'm her father.
Mr. Moore believes that the man with whom Miss Matthews posted the picture is actually the father.
Picture of Zanaya and then a picture of Mr. Moore as a child. Do you see a resemblance?
Their lashes, one, look at them, super duper long, and they both skinny as a stick.
Mr. Moore, do you see a resemblance at all?
Absolutely. I mean, every day I look at Zanaya.
And you see yourself?
Sometimes, you know, but then it's those days that come by that's a little slower, and I'm like, no, it's what everybody think till you get the result.
When you listen to what everybody thinks, one day you have to grow up and be a grown man and make your own decisions.
Explain it. Okay, you're right, but explain your disappearing ways. Stop answering text messages. Stop responding to my calls.
We need to address the retributions that Mr. Moore was seeking.
You say that you'd like the court to award you $285 for the broken window. Do you have any receipts? So this is a receipt from a car repair shop for $285.
Yep.
In open court, Ms. Matthews, you admit that you broke the window intentionally. Therefore, you are responsible. You cannot destroy someone else's property. So for that reason, my ruling is for the defendant for $285. Are we clear? Now moving on to the DNA results.
Now, let's see the outcomes.
In the case of Matthews v. Moore pertaining to year-old Zanaya, Mr. Moore, you are not her father.
That's what I'm talking about. That's what I'm talking. I'm done. I got my whole life ahead of me. I'm done. You know what I'm saying? I wish you the best.
Something in me is telling me that you know who this person is, and maybe when you get in the quiet of your own space, you'll be able to say, now self, because most importantly, we're here for Zanaya. We want her to know who her father is because she deserves that. I wish you the very best of luck. Court is adjourned.
Lux Irene Fajardo Campos, a female cartel boss known as La Dona, has been sentenced to 22 years in prison in the U.S. after her 2 sons were killed, which could have been a warning not to cooperate with U.S. prosecutors. Luz Irene Fajardo Campos was also called La Comadre and La Madrina, indicating her high-ranking position. Some collaborators also called her Yenka, a name she stamped on some packages sent to the U.S. by Ardo Campos, received her sentence for running an international drug trafficking network with her adult sons. They procured cocaine in Colombia and imported precursor chemicals to Mexico. She bribed law enforcement officials in Mexico and Colombia to use an international airport for cocaine importation. According to prosecutors, they sent cocaine and methamphetamine to the U.S. She was sentenced in the U.S. District Court for the District of Columbia for her role in a conspiracy to transport thousands of kilograms of cocaine and dozens of pounds of methamphetamine into the U.S. She was convicted of conspiracy to distribute 5 kilograms or more of cocaine and to manufacture and distribute 500 grams or more of methamphetamine in Mexico, Colombia, Honduras, and other places, knowing that the substances would reach the U.S. The man convicted of physically assaulting and robbing 3 girls at gunpoint has been sentenced. Prosecutor O'Malley stated, "This man physically assaulted 3 teenagers." He commended Judge Collier Williams for the sentence she imposed.
The facts of this case are considerably disturbing to me, extremely disturbing. Of the 3 women who were 18 years old at the time, some of them they were more than one time.
Bonner, 34, faces charges including 5 counts of assault and 1 count of aggravated robbery. He approached the 3 girls and brandished a handgun at the Rapid Station located at the intersection of Shaker Boulevard and East 116th Street on November 4th, 2017.
Only thing I remember is just going back to where I sleep at. I wish I could remember it I wish I knew what was going on. I wouldn't even been there.
The prosecutor's office stated that he forced the girls to the station's platform and physically assaulted each of the victims while pointing the gun at the others, forcing them to watch. The girls flagged down a nearby Cleveland police car, which then began to pursue Bonner. According to the prosecutor, Bonner was found hiding in bushes along Shaker Boulevard and was subsequently arrested. Griselda Blanco Restrepo, known as the Black Widow and the Cocaine Godmother, was a Colombian drug lord associated with the Medellin cartel. She was a pioneer in the Miami-based cocaine drug trade and underworld from the 1950s to the early 2000s. It is estimated that she was responsible for up to 200 killings while trafficking cocaine from Colombia to New York, Miami, and Southern California.
Wild West show down here, and that was really sort of Exhibit A. The land.
Miami saw dramatic changes in the homicide rate.
It was being imported by the ton, by boat, by plane, in cargo.
It didn't take long for Blanco to immerse herself in a life of crime. According to her former lover, Charles Cosby, Blanco allegedly kidnapped, attempted to ransom, and eventually shot someone from an upscale neighborhood near her own when she was just young. By teenage, Blanco had already become a pickpocket. To escape abuse from her mother's boyfriend, she ran away from home and turned to looting in Medellin until she was 20. Blanco emerged as a major figure in the history of the drug trade between Colombia and the United States, particularly Miami, New York, and California. In the mid-1970s, she and her second husband, Alberto Bravo, immigrated to the U.S. and settled in Queens, New York. There, they established a significant cocaine operation on a large scale. Their violent methods contributed to an atmosphere of lawlessness, especially in Miami, leading to a full-fledged drug war known as the Cocaine Cowboy Wars.
Something that we had never seen or heard of here in South Florida. The war wagon that was covered with bulletproof vests to make it almost like an armored vehicle. Police officers were still using 6 shooters, and these guys had these submachine guns. Police department itself were not prepared.
In 1975, Blanco was indicted on federal drug conspiracy charges, along with 30 of her associates. She fled to Colombia before she could be arrested, but later returned to the U.S., settling in Miami in the late 1970s. In 1985, she was arrested by DEA agents in her home and held without bail. Following her trial, Blanco was sentenced to more than a decade in jail. While in prison, she continued to run her cocaine business effectively. Nearly 20 years later, she was released from prison and deported to Colombia, where she was killed in a drive-by shooting in 2012. Adrian Loya was found guilty in a 2015 shooting rampage that claimed the life of a fellow Coast Guard petty officer and wounded her wife and a responding police officer. A Barnstable Superior Court jury in Chesapeake, Virginia, convicted Loya of first-degree murder with extreme atrocity and cruelty, deliberate premeditation, and 28 other counts after a week-long trial in 2017. According to testimony, Loya had spent over a year planning a revenge mission against Lisa Trupnikova, a former colleague stationed with him in Kodiak, Alaska, whom he believed had wronged him somehow. He meticulously planned this mission, which he called Operation Purple Rebel, and compiled a manifesto of his grievances against her titled The Wrath of Loya. He also traveled from his new station in Virginia to Cape Cod to plant hunting cameras outside the Trupnikova residence. Loya then shot the lock off the door of the Monument Beach condominium where Lisa Trupnikova lived with her wife, Anna Trupnikova. He entered the residence and found the woman asleep upstairs. After a brief verbal exchange, Loya fired 15 shots into a mattress behind which the women had huddled to shield themselves. 11 bullets struck Lisa Trupnikova, killing her, and 1 bullet hit Anna, seriously injuring her.
I had a collapsed lung from the wound to my chest, shattered, a wound to my left thigh, outer thigh. He said something along the lines of us getting married and that he doesn't believe in marriage and he doesn't think people should get married or it's not.
Going back outside, Loya retrieved a rifle he had hidden in a snowbank. As Officer Jared McDonald approached, Loya fired 4 shots at him, with one hitting the officer in the spine.
Anna's parents were there reading their statements. That was really when I wanted to see his reaction. It's nice to have justice served. It's not my decision. I don't have any any control over the situation, but I feel like justice has been served.
Loya had set his car on fire at the entrance to the condo complex and scattered fraud explosive devices around the neighborhood to delay police response. Although he initially planned to provoke the police and engage in a standoff, Loya ultimately surrendered. He is serving a life sentence without the possibility of parole at Massachusetts Correctional Institute Cedar Junction in Walpole. Recently, the state Supreme Judicial Court upheld Adrian Loya's first-degree conviction and rejected his request for a new trial.
First degree.
And what subcategory of first degree?
Deliberate premeditation and extreme atrocity.
Mr. Loya, what do you say to the victim's family?
Very, very sorry.
It was a gruesome scene in Anaheim as 2 male bodies were discovered with stab wounds in an apartment near Angel Stadium. A third man inside the apartment was injured and required medical attention. Authorities later announced that the injured man, 26-year-old Irvine resident Rami Fahim, had been arrested on suspicion of committing the crime.
Surviving subject that was removed from the apartment when initial responding officers arrived on scene. It was a pretty violent crime scene as well. It does appear to be an isolated incident that was targeted, so nothing to suggest that this was a random act.
Fahim was also present in the apartment and sustained minor injuries, although the specifics were not disclosed. He was taken to a hospital for treatment before being interviewed by homicide detectives, who subsequently arrested him on suspicion of the killings. While authorities did not speculate on a motive for the slayings, they mentioned that Fahim and Cuomo were co-workers. Surveillance cameras in the apartment building, as well as doorbell cameras owned by some residents, captured footage relevant to the investigation. A neighbor's camera reportedly recorded Fahim in the building hours before the killings. Police utilized this video evidence to establish a timeline of the incident, indicating it may have been premeditated. The special circumstances of lying in wait and multiple homicides make Fahim eligible for the death penalty. However, it is highly likely that he will spend the remainder of his life in prison. It sounds like this. Karen took her frustration from the dating scene to the courtroom.
Morning.
I want you to know that you made me famous for about 20 minutes or so. Apparently I came out on TikTok doing a plea.
Okay.
My niece and nephews and my sons and were all calling me and I said, Dad, you're famous, you're famous.
Oh.
You're on TikTok.
Well, and you know what's so funny? Somebody asked me one time, they said, are you on LinkedIn? I said, I think I was on LinkedIn from 1997 or something. Yeah. So I do not know much about the technology. I'm trying to work on being more tech savvy. All right. Court is calling 2024 CR 0937, State of Texas versus Alfredo Lugo. Just for a moment off the record. Counsels, if y'all could not talk behind the court reporter, because we're on the record, if you want, the deputy can move you down to the other end. All right, back on the record. Could I have parties announced for the record for the state?
Ed Garza from Mr. Lugo.
And are you Mr. Lugo?
Yes.
Counsel, have you received all the discovery and did you review that with your client?
We did, yeah.
You're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? Application for deferred adjudication. If for any reason your deferred adjudication were revoked, the court could, off the record for a moment, excuse me, the lady in the black top with the red or burgundy spots on it, are you on the docket today? Are you here for someone else? I'm sorry? All right, so you need to move because you're flirting with the inmate. That's not allowed. So you need to step outside. Deputy, remove her. And who were you here for?
Inmate here with the gold glasses.
All right, guy with the gold glasses. And lady, you're flirting with somebody who's an inmate. That means that he's not doing anything for you. And you're down here where you should probably be at work. And if you have children, you should be concentrating on your children. You're not allowed back in the courtroom. You're excused. You know you should not be flirting with people in the crowd. This is not a dating show.
The judge punishes this Karen with a significant fine for submitting documents written with crayons.
This is a joke. I can't even read
the discovery that was given. It's like done with either color crayon or pencil. I can't read half of it. This is not in keeping with the order of the court. I don't know if the court wants to have Judge Evans review this, but I can't use this discovery. I can't even read half the words on it. I've never had.
I'd ask Ms. Fowler if she has anything to say.
Your Honor, I complied with the court's order.
Okay, Ms. Fowler.
Judge Evans ordered me to take.
Ms. Fowler, we're not even going to go there. I saw what you submitted. I don't know if you think you're being clever or funny, but that's in no way, shape, or form compliance with the discovery requirements. So the order was that you were to pay $1,000 in fees unless you did comply with discovery. So you owe that $1,000 in fees. I'm putting this on in 2 weeks, August 1. If you have not submitted proper discovery answers, it's going to be another $1,000 in fees. If you want to continue to play whatever game you think you are playing, just be aware it's going to cost you a bunch of money. The other thing that will probably happen is if you continue along this path, is your pleadings are going to get stricken, and Mr. Reed get pretty much what he wants. Is there any part of that you don't understand?
The only question I have is I was ordered by the court to take pen and paper or whatever I had to write and respond to discovery. And I did. I did what I was told.
As I say, I don't know if you thought you were being clever, but that is in no way, shape, or form compliance with discovery. If you can't figure out how to comply with discovery, I suggest you talk to an attorney or contact the legal aid program. But it's obvious that you thought you were being clever or funny with this. And I'm just not going to put up with it. And there's no reason Ms. Cotto should either. So August 1, 9 o'clock is your deadline. It's going to cost you more money if you continue to pull what you think is the same stunt. Is that clear?
Yes, Your Honor, it's clear to me Mr. Reed's gotten his way this entire time.
That will be all.
Okay. I will submit an order. It looks like, and it's difficult for me to read, but Ms. Fowler has the confidential address program, but I can't read the P.O. box number. Could she please provide that on the record so that I can mail her the proposed order?
What's the P.O. box number, ma'am?
Pulling my crime and domestic violence card right now. It is P.O. Box 6, and keep in mind, those are screened, and the ones that are forwarded do take several weeks to get to me because it is going through a rerouting program if it passes through the screener.
All right, well, I suggest you get your discovery to Ms. Cotto's office right away.
Thank you, Your Honor. I will prepare a proposed order also and have that ready for presentation on the 1st.
All right.
Thank you.
Despite claiming to be sick, Karen exhibited no signs of illness as she boldly confronted the judge, challenging the court's authority without hesitation.
You're going to have to talk to somebody or something because you're going to test on Friday. So you have 2 days to figure it out. You're to test on Friday. No excuses. You're to test on Friday. There's an allegation. First of all, you're on bond because of a drug charge, and there's an allegation that you tested positive for additional substances. And then you were here at court last week, and then you left, and then you didn't test when this court orders you to test. The court has concerns, ma'am, that you're not maintaining your substance-free bond conditions. So you're to test Friday.
See you on the 28th. Thank you, Ryan.
Anything else, counsel?
No, Your Honor.
Anything else, Ms. Hoffman?
I have a lot to say, but I don't know how to address the court.
Okay, what's that?
You are saying that I'm being charged with drug paraphernalia. And I asked my attorney, like, if it was going to be specified that it was for a torch lighter. You keep saying drug paraphernalia, like I had drugs on me, and I did not. So I just want, and then when I took the plea, also I tried to talk to my attorney about withdrawing the plea because this has affected all kinds of stuff with my probation, where I might not even get a 7411 over a torch lighter that I had because I took a plea of being guilty of drug paraphernalia of a torch lighter.
The sudden shift from appearing weak to displaying disobedience raised eyebrows among those present. It became clear that Karen's illness might have conveniently disappeared when it served her interests.
And what are you on probation for, ma'am?
I have 3 or 4 charges on me.
For what?
And that's the thing, like your facial expression that you just made when I said charge. And then when I hear the prosecutor like speaking on me, saying that I know the routine, to have my attorney pick which plea I wanted to take and all kinds of stuff. Before I even stood in front of you, I talked to my attorney and I asked him, what if I want to take it to trial? He advised me that if I didn't want it to mess with my driving record and for me to move on with my probation in Macomb that I've been dealing with for a year, that just to take the paraphernalia for later. And it's become a nightmare for me, an absolute nightmare. I've been on the right track. I go to IOP. I do all the things I'm supposed to be doing. And I have been with your facial expression, because I said I charge, like, I don't know what you want me to do. That's my past. That's what I did before. That's what I don't do now.
Ma'am, what I said was, because, excuse me, Ms. Hoffman?
Yeah.
Okay. What I said was, and I had a facial expression with that comment because I have concerns for your substance use based upon your charge, your bond violation, and the fact that you are currently on bond or probation for additional charges. That is the point of that. It wasn't to judge you for your past. It wasn't any of that. It was to prove a point that I've been making this entire time, the 3 times that you've been on the record today. I have concerns that you are not maintaining a substance-free lifestyle right now. So it isn't for any other reason but for that.
You said because of
I have no control over the prosecuting attorney or anything of that nature, ma'am. I have no control over your defense attorney. I don't have any control over that. I was simply making a comment that supports that this court's concern is supported by what's currently pending for you in Macomb County, the allegations here in this court, and the bond violation allegations. That is what I meant when I made the comment of, Yes, Mr. Goldbaum?
Nothing, Your Honor. I just, she's made some comments, and I guess that if there comes a point in time, and about withdrawing pleas, that would be something that, to be quite honest with you, I advised her of all those information. There was comments made that she just said regarding I should take something. That was not what I told her. She was always given the opportunity to take this matter to trial. We discussed this matter. We negotiated the plea. Ms. Taylor went out of the way to provide her with all of her prescriptions. Ms. Taylor requested an adjournment. As part of the pretrial, we got the discovery. We gave people her list of prescriptions. There were some discrepancies. It was for that reason why they were not going to dismiss outright any drug charges.
Which I said I could provide the proof of my medications, which I said I can provide the medications. And the whole thing with the you said with my charge, it's for a torch lighter. They didn't find on me.
Thank you.
That's what I don't understand. Like it's being misconstrued, and then you're saying I don't think you're staying on the right path. Well, what about all the stuff that I can provide? Where I go to my intensive outpatient, that I talk to my counselor, that I go to meetings, that I drug test. What about all those things?
This mother attempted to abduct her own child from the custody of the father.
Has had minimal contact with the child, even though the parties share the same residence. She has taken to locking herself in her bedroom. She repeatedly hits the child, and most recently she bit the child, leaving a bruise on the child with teeth marks.
Your Honor, if it was the case if he was feeling unsafe with me with our child, why is our child in my care right now?
Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Reed.
Thank you, Your Honor. The parties share one child together. That's Joseph, who's age 4. Plaintiff is requesting sole legal, sole physical custody of the minor child. The defendant having supervised parenting time. The defendant has had minimal contact with the child, even though the parties share the same residence. She has taken to locking herself in her bedroom. She repeatedly hits the child, and most recently she bit the child, leaving a bruise on the child with teeth marks. The child is afraid of her, and due to her lack of supervision, the child has been permitted to wander off while in her care. And for all these reasons, my client does not let the child be alone with his mother. There's usually himself or a roommate, or the child is in daycare, so the child is not left alone in her care. Since she has been served, there's been repeated threats to kidnap the child. Last week, she has stated that if it does not today, that it doesn't matter what the court is going to do, that once my client gets home from work, she will not be at the home, the child will not be at the home, and he will not be able to find her. For all these reasons, we're requesting that she have supervised parenting time, submit to a psychological assessment with Dr. Haugen, and my client gets sole legal and sole physical custody. He is trying to find alternate housing to try and alleviate some of the stress that's going on in the house. But until the parties separate, we believe supervised parenting time is appropriate.
Okay. Mr. Pecos, what's your response?
Is that on to me now?
Yes.
The allegations are not fully accurate, Your Honor. I want 50-50 custody, and I request an appointed attorney.
Okay, ma'am, we do not appoint attorneys in these types of cases, so you'll have to acquire an attorney.
Okay, I just wanted to ask. But also the allegations are fully out of bias. They are out of context. And I am also going to get help for my depression, yes. But I believe that the child deserves 50-50 custody. And I am not saying Jeremy does not have a right. And also, with him knowing the fact of the allegations, are not fully understandable. He basically is taking bits and pieces of it, Your Honor. Yeah. And for right now, if it was the case, Your Honor, if it was the case if he was feeling unsafe with me with our child, why is our child in my care right now?
Well, anything else, ma'am?
No, not seen, Your Honor.
Anything else, Ms. Reed?
Yes, Your Honor, it's my understanding that the child might be in the care of the defendant right now. She made threats of getting potential PPOs against child care providers to bolster her case, and then went back on those threats. We don't know how valid those threats are, but that was part of the threat of kidnapping after today's hearing, was that my client wasn't allowed to permit the child to go to child care today, so the child would be in her care pending the result of today's hearing.
Okay. Anything else, Mr. Pecos?
Your Honor, I asked, and also the caretaker actually even asked me if I wanted Joe home today, and I said yes. In my opinion, our friend who is staying with us was here to help me, not hinder me. she also has stated to his lawyer that she will also be defending me on my behalf also, Your Honor.
Okay.
And I was informing him of what my sister was telling me what to do. But Your Honor, I would not do that to him.
Well, ma'am, just so you know that the child is in the jurisdiction of this court, and the court, when I grant, whatever I grant, that will be an order of the court. If you violate that court order, you could be held in contempt of court, you could be put in jail. So all I'm saying is that whatever that order is, you're gonna need to comply with that order.
Yes, Your Honor, I will fully comply with your ruling. I'm not going against it whatsoever.
Okay.
But also, he is not home every day, and he is in childcare from all the way till 4 a.m, all the way till he gets home at midnight.
Well, that's always unfortunate, and we'll maybe have to assess that at some point in the future as to what we're going to do in this matter. What I'm going to do on a temporary basis, I'm going to grant to the parties temporary joint legal custody. I'm going to grant physical custody to the plaintiff. The parties are, again, apparently still residing together, so they can work out parenting time in the meantime. If in fact there is no agreement, then the court would grant to the defendant standard parenting time, which is alternating weekends, one night through the week, alternating holidays, etc. Court will grant child support consistent with the child support formula, the incomes of the parties. And I'm not going to do anything as it relates at this point to the psychological assessment. The defendant has represented that she's going to get help for her depression. So, ma'am, when you do get help for the depression, provide that information to Miss Reed so she would have the information as to where you're going, who you're seeing, because the court will at some point want a report from that particular counselor. Anything else, Miss Reed?
Is the defendant's parenting time supervised?
No, I'm not going to do that at this point. Again, depending upon anything happening in the future, the court could review that at that particular time, but I'm not going to at this time.
I have nothing further.
Mr. Pekas, anything else?
No, Your Honor.
Okay, that will be the order of the court. Ms. Reed, you can prepare an order pursuant to 7-day notice of entry, and we'll have that order take immediate effect as of the time of this hearing.
All right, Your Honor.
Okay, thank you.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.